Hello everyone, it's Wayne Jones, the course coordinator in the placement course for this term. I wanted to give you a few ideas from personal experience about entering the plea of guilty. Now, I need to qualify that by saying that although I have appeared in other courts, primarily my experience in entering pleas of guilty was in the Magistrates Court. And I think for most general practitioners, that's going to be your experience as well. When it's a more serious matter, certainly in the Supreme Court or even in the District Court, if there's a fair prospect of imprisonment, I suspect that many of your clients would be quite happy to engage counsel. So let's just talk about appearing in the Magistrates Court on behalf of the client who's given you clear instructions that they want to enter a plea of guilty, but they want their best case put forward. I'm just going to share the screen if I may. Okay. So this is just about entering a plea of guilty. This is not necessarily about a negotiated plea, which is a whole other thing. But as I said, your client's giving you fairly clear instructions. That's what they want to do. So hopefully I'll be able to explain to you what to do to be prepared to represent your client, understand what might be useful, because remember, as soon as you start to wander and become a little bit irrelevant, the magistrate's going to pull you up, and try and understand the purpose of a well-presented plea of guilty. All right, well, pleading guilty. If the accused pleads guilty or is found guilty, the court will conduct a plea hearing. So a few different descriptions, but basically the same thing, just a plea of guilty in the court. Now, typically in the Magistrates Court, of course, the clerk of the court or the magistrate will read out the charges. More usually, it'll just be the magistrate. He'll read out fairly quickly, 3 counts of breaching such and such legislation. At this hearing, both the prosecution and the defence present the information they want the judge to take into account when deciding the sentence. So that's what this is all about. Now, the magistrate will want to hear the facts which are relevant to the sentencing. And this is going to include prior criminal history. The principles of sentencing come mainly from legislation. And what I'd ask you to have a look at when you get a chance is the Penalties and Sentences Act. Now, here's just a little extract of it to give you a feel for what you're going to see. This is Part 2, Section 9, some of the governing principles. So it gives you a feeling for the legislation itself. The only purpose for which sentences may be imposed on the offender are to punish, to provide conditions, to help rehabilitation, to deter, to make it clear to the community that this conduct is not going to be tolerated by the general community, protect the Queensland community from the offender. Now, I'll just stop there for a second, because what you might often hear from a magistrate who's quite happy with what you've said about reasons in mitigation of what has happened, you will often then hear the magistrate say that I've got to balance that. I hear what you're saying, Mr. Jones, but I have to balance that against my obligation to protect the Queensland community from this offender. Now, that might be, for example, if the offender has a long history of similar sorts of things. And I'm thinking particularly of juveniles who've been involved in stealing cars, for example, or juveniles who've been involved in long strings of breaking and enter. Magistrate may hear and like everything that you've had to say, but be aware that they are thinking about these governing principles as well. So they're thinking about, well, I need to deter other offenders from committing the same sorts of offences. I need to make it clear to the community that we're denouncing this sort of conduct, and I'm trying to protect the community. So you don't get you don't get to pick and choose which of these governing principles are going to be applied. The magistrate's going to come back at you too and say, look, these are some of the things I need to do. When you get up to the bar table, prosecutor will sit on the right, you sit on the left. Prosecutor always goes first. And they'll start by reading out the particulars of the facts that led to the arrest from a form called a QP9. I'm only mentioning that because you'll hear the term thrown around. basically just a couple of A4 size sheets that have got information from the arresting officer. So it's not a brief of evidence, it's just a bit of information, and attached to the back of it will usually be the criminal history of the person. Should make it really clear that pleading guilty means that the accused accepts the facts as they're read out. Now, if you are dealing with a decent prosecutor, you can often have a conversation with them in advance to do a little bit of horse trading. Clearly, you can't go too far, but I guess the most typical example I can think of is if there's been a fight in a bar and the facts allege that, say, the accused person struck the victim, half a dozen times or something like that. Your client may say, well, that's just an exaggeration. Look, I hit him one time, hit him with an open hand, and I hit him across the face. And I know I shouldn't have, but this is just gilding the lily a bit. Prosecutor will often, think about whether that's close enough, and justice can still be done, if I put it that way. But that can only go so far. But pleading guilty generally means that you're going to allow the prosecutor now to stand up and read the facts as they appear in that QP9. So it's important that you do have a quick look at that beforehand, just to get a feel or get an idea of what's going to be alleged on the day. Sometimes you might need to write to police in advance and say, can you send me a copy? And they'll shoot you over a copy. If it's on the day, they'll usually let you sit there at the bar table and read it. Don't ever make the mistake of taking documents away. You just don't do it. You don't do it. You sit there with the prosecutor, so they really need to know where all their file is. So it's a courtesy they're extending to you to have a look at the QP9, sit there at the bar table and read it. Don't take it outside. And as I said, this will usually include prior criminal history. Not always, but sometimes the prosecutor might say, well, we're suggesting that a custodial sentence is the only sentence you can apply, or a fine may well be appropriate, whatever. They don't have to say anything. The magistrate may ask them. It's really only in circumstances where they've got something to say that they'll definitely say, well, look, we think that this has gone on long enough. This accused has had way too many chances. It's really getting close to time for a custodial sentence. All right, now it's your turn. Now, look, before I do, can I just slip in something that I meant to mention earlier? When your client is entering a plea of guilty, the magistrate wants to hear it from them, okay? You don't, it's not a good idea to, you can indicate to the magistrate your client intends to enter a plea of guilty, that's fine. But when it comes time to those magic words, pleading guilty or not guilty, the magistrate will look to the client. They want the client to be on their feet, to be standing. So if your client's still sitting at the bar table, give them a poke, get them to stand up. And the magistrate will say, are you pleading guilty or not guilty, Mr. Jones? And the client will say, I wish to plead guilty, or guilty, Your Honour. Righto, now back to this, submissions. Well, what do you want to start with? We'll just start with a bit of background, but don't go over the top. If everything you're about to say has just been said by the police in the QP9, single man, age 35, lives with his mother, what have you, well, at the very least, I think you should just say, look, the personal details as read out by the prosecutor are correct. He does live at home with mum and he's 25. Don't labour it. You don't need to repeat. Are they supporting children? Are they working? Are they studying? Just give the magistrate a very quick, and I do mean quick, a very quick history of who your client is. And at this stage, you might indicate any personal problems that they're having that explain the situation. And honestly, the one that just popped into my head then was for oftentimes people who, particularly women who in my experience, have been stealing from their employer. I experienced a real run of them at one point where they were all having problems with gambling. And so that's fine. If you're going to say, I'm here because my client has a serious problem with gambling that she's trying to address. So yeah, that background information doesn't excuse, but it starts to give an explanation to the judge about what's going on. If a fine is likely, if you're very early on in your submission saying, Your Honour, we're going to submit that a fine's the most appropriate, you better explain to the magistrate that your client can actually pay it. So The client is employed. They have a rent obligation of $300 a week, or they're paying a mortgage, similar amount. Don't have any other large loans, and would be in a position to pay and always say a modest position to pay a modest fine. If they're going to have trouble paying the fine, and you think that's the way the magistrate's going, there are some options. So they can do community service work, for example. Be aware, though, that from experience, I know that excuse me, people who have any sort of a disability are not likely to be accepted into community service. Terrible thing, but it's a fact of life. Where they'd be doing heavy work, for example, at the town dump, sorting through recycling or what have you, they're going to need a good back. They can't. They need to be able to stand for lengthy periods of time, etc. And it's a tragedy, but unfortunately, there's not too many community service options open for people with disabilities or injuries or illness. I wanted to say nice and early that if you might as well be realistic. If your client's looking at a prison sentence, just face it squarely. Just say, look, we're going to ask you for X, Your Honour, but my client is well aware that one of the sentencing options, because of his behaviour, is that you may be looking at a prison sentence. Now, again, I'm thinking of social security fraud. Generally, in social security fraud matters, the Commonwealth prosecutor will push for a custodial sentence. Now, there's a reason, there's a sting in the tail for that, but they will typically say to the magistrate, these offences are becoming more prevalent, they're difficult to detect, both submissions of which I think are a bit questionable, but anyway, difficult to detect. Taking money from the community, where similar sentences have been passed in recent times, we're suggesting 12 months jail. Now, don't panic too much, because that is often the case with social security fraud. You've got to then jump up and start talking about, well, whether that prison sentence, which has a good deterrent value, would be better served as a suspended sentence. Now, that just means that your client's been sentenced to 2 years imprisonment. It's wholly suspended, but within that 2 years, if your client commits another offence, they're brought back to the court, they're resentenced for this original offence, and of course their new offence is dealt with at the same time. That's often the sentence that's given by magistrates in the case of social security fraud: 2 years imprisonment, wholly suspended. And also think about things like the time served to be eligible for parole. But what I'm really getting at here is, if prison is likely, then you might as well face it and come up with a couple of strategies with your client about what your submissions are going to be. I'll put the clock on. There's one strong point to make, because if you are losing the magistrate's attention, and you, more than anybody else in the room, you'll know, get these half a dozen points down quickly, because before the magistrate stops you and says, look, I don't think I need to hear anything further, thank you very much, unless you've got something very relevant. Right at the top of the list, remind the magistrate, if your client is pleading guilty on the first time they've come to court, sometimes called the first return date, tell the magistrate. Secondly, the people who are supporting the accused in court, if there are there, it's always good to say, look, my client's a young man, his parents are here in court supporting him today, because the magistrate sees then that there is a network behind the accused person that will assist them to stop this behaviour. They don't need to rely on community corrections, for example. Mum and dad are here, then you know that there'll be trouble at home. How and why the offence happened, by all means, but particularly if alcohol is involved, you are only mentioning that from the perspective that you're trying to say, look, this is totally out of character, let his head go, drank too much, what have you. It's explaining, it's not trying to excuse the situation. This is another really important point. Anything that the accused can say that they've done to try and make up for the offence or to accept some responsibility. So if it did involve damage to the neighbour's property, for example, that they have offered restitution or they paid it already, it's always good to say client cooperated fully with the police. A little bit hard if one of the charges is resist arrest, but anyway, they did cooperate with the police, made a full statement, and offer a sincere apology to the victim. Really got to demonstrate there's been some empathy towards the victim. So that leads on to my next point, which is you're talking about remorse. You're not trying to say, for example, you often hear this in those crazy footballer submissions to camera, oh, I'm really sorry about what happened and I just want to put it behind me and get on with things. Well, the crazy thing about that is not really showing any remorse. So you're not saying, I'm sorry I got caught, saying my client is extremely remorseful for what happened, totally out of character, is embarrassed, and is such that he's not going to let it happen again. So that's what they've learned and how they feel about it. The magistrate will often want you to say, well, okay, so what are they going to do about it happening again? I'll put down their new address as one of the possibilities. Oftentimes magistrates simply want to hear that, look, okay, they've got in with a bit of a bad crowd, but they've done something about it. They've moved town, or they've moved out of one suburb into another, moved back with mum and dad, something like that. Got a new job, so we're now a little bit more occupied, seeing a counsellor, or actually just doing a drug and alcohol course. All useful things, but if you can mention any of those, they're great. Some more strong things to always have on your possible list. Definitely, even if the prosecutor has already said it, if your client has no prior convictions, put a different spin on it. Say, Your Honour, this is the first time my client has ever been before the court. Really, really hammer that one. Their youth, that'll be obvious, but also still a young man, Your Honour, still a young woman, Your Honour, whole life ahead of them, made a silly mistake, deserve a second chance. Getting a job, keeping the job, travelling overseas. These are all reasons why you're saying to the magistrate, we accepted that he or she has pleaded guilty. They pleaded guilty early. This is a situation where you can find them guilty, but order that no conviction be recorded against their name. And that means that they can still honestly say, when they're applying for jobs, whatever, I have no relevant criminal convictions in Queensland. I'm not such a fan of this, but one of my colleagues brought this to our attention in these slides. I've made some changes to these slides, but not a great fan of it. It's really got its place, but handing up documents like character references, etc., they can be useful in their place and on their day. Of course, the famous thing that lawyers say about good characters is everybody had one once. They really have to be relevant to what we're talking about. And the best example I can think of a document that might be useful would be if a person was pleading guilty to drink driving but needed a driving licence, they might hand up a letter from their employer saying just that. I can't really keep them employed without a licence. Usually that's also one of those situations where the magistrate wants to hear, they might very well want to hear that from their employer that they thought they're a person with good character. But for 9 out of 10 appearances, I don't think a character reference is going to do you much good. I don't think there are too many bits of paper that you should be handing up. Now, my final word as an old legal aid lawyer is this. You must always make sure, if you're entering a plea of guilty, that you get your client's instructions in writing. Prepare them for the worst, and they will maybe thank you, possibly not, but prepare them for the worst. But always get there, particularly for a plea of guilty, get their instructions in writing. Even if you're there as duty lawyer, you are meant to have the duty lawyer form signed by the client saying, they acknowledge that they want you to enter a plea of guilty. They acknowledge the right to a trial, but they want the matter dealt with today. So, and that will save you a lot of grief later on when the sentence is worse than everyone was anticipating. The client blames you. So look, that's just some thoughts on a plea of guilty, and there's likely to be an exercise on this in due course. So think about those things, but definitely go and have a look at the Penalties and Sentences Act to see what it has to say. Look, I should know, and I'll see if I can find out for you, but you used to be able to get access to a database of similar sentences from legal aid. track that down if you can. See if you can get access to that. It tells you what sort of sentences are current at the moment for different offences. You know, what sort of penalty should your client expect, say, for a first offence, break and enter, something like that. So legal aid used to keep those stats. See if you can hunt those down as well. But certainly have a look at the Penalties and Sentences Act. We'll talk again soon. Thank you.